Attorney-at-Law John Jeremy, Senior Counsel of Trinidad and Tobago, who is representing the interests of the petitioners, maintained that Order 60 of 2020 was drafted in bad faith, while also establishing that Section 22 of the Constitution does not allow GCOM to act the way it did when it drafted Order 60.
The regime created under Order 60 by GCOM purportedly, in pursuance of 22 of the election law and Article 162 of the Constitution, is itself ultra vires and inconsistent with 161E of the Constitution.
Jeremy further argued that GCOM acted unlawfully when it embarked on the national recount exercise, citing that only an election court has jurisdiction to open ballot boxes and further inquire into discrepancies.
It usurps upon the power of the High Court to set aside declarations.
Okay.
And also to resolve election disputes. That's a matter for the High Court.
Meanwhile, Attorney-at-Law Anthony Astafan, Senior Counsel, who represented the Chief Election Officer on behalf of the Ghana Elections Commission, submitted that the Commission acted as it deemed necessary and within the ambit of the law, according to Article 162(1)(b) of the Constitution, which says that the Commission, and I quote, shall issue such instructions and take action as appears to it necessary or expedient to ensure impartiality, fairness, and compliance with the provisions of the Constitution. Astafan posited that GCOM literally has a mandate to act based on difficulties, which it did in the case of the electoral saga, following which it embarked on the national recount exercise of 2020. He further stated that for the petitioners to submit a mere breach of the law statement and expect a different result is absurd. While he brought to the attention of the Chief Justice the words of Justice Singh, who presided over an election petition in 1997.
That a mere breach of the law is not sufficient. And we respectfully submit that the petitioners were required to plead and or show and or submit the following, which they have not done. 1, total non-compliance with the law.
Attorney-at-Law Douglas Mendez, who appeared on behalf of Vice President Barrett Jagdeo, proffered that Parliament can delegate its authority, given that the principles of delegation are clearly outlined, as in the case of Section 22 of the Constitution. In that regard, he proffered that Section 22 is not unconstitutional, and therefore GCOM acted within the ambit of the law. Continuing with his submissions, the attorney said that even though Order 60 authorized a departure from the strict provisions of the Representation of the People Act, it was enforced to clarify and remove difficulties which arose in the election process.
The only major difference between Order 60 and the normal procedures is that the returning officers are not doing the recount themselves, but it is being done by GCOM employees under the supervision of the Chief Elections Officer and in the presence of all of the political parties.
The decision as to whether Section 22 of the Constitution, as well as Order 60, are constitutional, now rests solely in the hands of the Chief Justice. Wendell Badrie, HGP Nightly News.